How are you guaranteed a commission at the close of a successful escrow? Ensuring your ability to receive payment by merely including the commission details in the contract doesn't ensure payment. A distinct commission agreement is crucial. This is because the parties involved in the contract can void, breach, or mutually modify any term, including the commission. Consider this scenario. If the contract is the sole agreement for commission payment, and the obligated party, seller, refuses to pay, would the other party, buyer, contest this decision? It's unlikely. Therefore, it's advisable to establish a binding, enforceable agreement with the party responsible for payment, such as a listing or commission agreement. Heading into escrow without a signed listing, commission agreement, or any fee arrangement from the party obligated to pay the commission, and relying solely on contract language stating you'll be paid, could lead to receiving nothing, which has occurred. In such a scenario, winning a commission lawsuit would likely be challenging since there was no contractual agreement for payment beyond the language in the contract. A provision not robust enough, as the contract is an agreement between the buyer and seller. In typical residential transactions, one agent sells a property, buyer's agent, listed by another agent, listing agent, on the MLS. In order for either to receive a commission, they must have a written agreement to obligate the buyer or seller to pay a commission. However, situations occasionally arise where a non-subscriber to the multiple listing service, MLS, such as a commercial broker, comes across a listing that they wish to sell to their client. This discovery could be through spotting a sign, finding it online, or encountering an ad in the newspaper. Since they are not a subscriber to that specific MLS, there is no automatic offer of compensation. To secure payment for selling the property, the commercial broker must take proactive steps. They can either approach the listing agent before submitting an offer and request compensation in writing, or they can ask their buyer to sign the Buyer-Broker Exclusive Agreement, BBEEA, and agree to compensate them. Emphasizing the importance of having buyers sign the BBEEA is crucial, as it serves as protection for the commercial agent in case the listing agent refuses to provide any compensation, a possibility within their rights. Today, the commission is not offered in the MLS anymore. The buyer's agent must send a seller compensation addendum along with the offer to the listing agent. This also has to be checked on the contract that this addendum is incorporated into the offer. Line 37 is where you will find the seller compensation for the buyer's agent. This is also negotiable. You do not just ask for the percent you would like. The seller may or may not negotiate that amount. There may be instances when you find the need to sell a property beyond your MLS area. Consider a scenario where an agent in Tucson, who is a subscriber member of the Tucson MLS, wishes to facilitate the sale of a property in Sedona to their friend. During a visit to Sedona, they attend an open house organized by an agent affiliated with the listing agent's firm, although not the listing agent themselves. The friend decides to purchase the house, and as both agents use AAR forms, you draft the purchase contract and submit it to the listing agent. Don't forget your seller compensation addendum. The agent presents it to the seller, leading to the opening of escrow. The sellers will decide if they wish to agree to your request of a commission or not. That is where your buyer-broker employment agreement comes in. If the seller is not willing to offer a commission for bringing them a buyer, your buyer will be on the hook for what you and your buyer have agreed to regarding commission on a successful close of the transaction. Here are the reasons. In any MLS now, there is no offer of commission to the co-broke. It is new. Yes, and can be time-consuming to see if the seller is willing to offer any commission to you, the buyer's or selling agent. Code of Ethics Article 3, Standard of Practice 3-1 says, Realtors are, acting as exclusive agents or brokers of sellers, landlords, establish the terms and conditions of offers to cooperate. Unless expressly indicated in offers to cooperate, cooperating brokers may not assume that the offer of cooperation includes an offer of compensation. Terms of compensation, if any, shall be ascertained by cooperating brokers before beginning efforts to accept the offer of cooperation. Amended 199. The last sentence says it all. Terms of compensation, if any, shall be ascertained by cooperating brokers before beginning efforts to accept the offer of cooperation. Upon visiting a property beyond your MLS area and receiving interest from a potential buyer, it is advisable to promptly reach out to the listing agent to discuss compensation. Any compensation that the seller is willing to offer will credit what your buyer has agreed to on your buyer-broker employment agreement. Most listing agents will tell you to just send the seller compensation addendum along with the purchase offer. Think about it. The seller said that they would offer a certain amount. The buyer's agent, wanting to have a good offer, sent discounts his or her commission, and the seller saves money. Yes, it is up in the air as to what will be agreeable to the seller. In some cases, the seller will not be willing or able to offer any commission to the buyer's agent. However, these steps become less imperative if, prior to leaving Tucson, you ensured the buyer signed a BBEA. Recognizing that you are not subscribed to the Sedona MLS, addressing this matter beforehand can significantly mitigate potential challenges. If the buyer declines to sign the BBEA, you would be aware of this before viewing any property, allowing you to inquire about compensation directly with the listing agents through the new seller compensation addendum, unless the listing agent offers you that information up front. In various realms of real estate transactions, such as those involving commercial, industrial, and land properties, brokers frequently rely on verbal or handshake agreements to facilitate the sale of a property. A discerning buyer often engages their attorney to create the contract, wherein brokers are commonly designated, and the seller's obligation to pay the commission is outlined. It's not uncommon for brokers to forego a separate commission or listing agreement, trusting that when the deal concludes, everyone involved will receive their compensation. However, there have been instances where buyers and sellers colluded to disregard or breach the contract clause, leaving agents without recourse. Despite potential anger and threats from the agents, legal action may prove challenging, as neither the seller nor the buyer may be held accountable due to mutual waiver and the absence of a commission agreement signed by the seller. One morning, a prospective buyer contacted you, expressing interest in viewing a property you had listed. Agreeing to the request, you arranged to meet them at the property. During the visit, the potential buyer concluded that the house was too small for their needs. In response, you offered to showcase another property in the community, which was accessible via a lockbox. They were in agreement and expressed their liking for a property, prompting you to draft an offer. However, despite your efforts, the seller opted for a different offer among the 3 they received. Disheartened, the buyers decided to persevere in their search and requested your assistance in finding a specific 4-bedroom model within that community. In the ensuing weeks, you presented various properties to them, but none aligned with their requirements. Then, after 7 weeks of collaboration, during which you submitted one offer and toured at least 20 homes, another agent in your office obtained a listing for the exact 4-bedroom model the buyers desired. Hastily, you arranged a viewing, and the buyers concurred to proceed with an offer. As you diligently filled out the contract, reaching the 10th page, you completed your details. In Section 8, you marked the box indicating that, as the buyer's representative, you represented their interests. The buyers signed the contract, and you promptly submitted the offer to the listing agent. The seller accepted, leading to the initiation of the escrow process, and you submitted the file to your broker. 3 days later, your broker notified you to amend Section 8, specifying representation for both the buyer and seller. Additionally, you were instructed to submit both the READ form, signed by the buyer, and the limited dual consent form, signed by both parties. Realizing an oversight, you had not obtained the necessary signatures for the READ and the BBEA forms, and had failed to discuss agency matters with the buyers. In light of this, what steps should you take? A. Contact the buyer and arrange a meeting to fulfill the broker's requests. Ensure that all required forms are completed, but exercise caution when backdating them to the appropriate dates. In some cases, it may be better to acknowledge any mistakes and get the task done promptly. B. Reject the option of sitting on the broker's request. Instead, submit the forms to the title company and request them to include these documents in the packet for the buyer's signature at the closing. Following this, submit the completed forms to the broker. Avoid trying to shift responsibility for your mistake. C. Schedule a meeting with your broker to clarify the procedure for the task. If you are uncertain about whether to backdate the forms, seek guidance to ensure you follow the correct protocol. It is crucial to understand your broker's preferences, as they are responsible for maintaining the file. D. Disregarding the request and hoping the broker will overlook it after closing is not advisable. This approach is akin to ignoring a problem, hoping it will resolve itself. Address the issue promptly and find a resolution, as avoidance will not lead to improvement. Is not a wrong answer, but be careful backdating the forms. Sometimes just getting it done and admitting to yourself and possibly the client that you made a mistake is the best way to go. B is incorrect. That means you are trying to avoid the issue and are asking someone else to clean up your mistake. C is the best way to go. Since your broker is required to maintain the file, it would be best to determine exactly how the broker wants you to accomplish the task. D is wrong. It would be like ignoring an infection hoping it goes away. Deal with the problem now and get it solved because it will not get any better by being ignored. Occasional errors are inevitable, as everyone is prone to making mistakes. Reflecting on the various aspects of this situation where missteps occurred, it is crucial for all of us to glean valuables from these experiences. The identified mistakes include: 1. Failing to establish the agency relationship before showcasing the property to the buyer. The discussion on agency should have taken place during the listing after the buyer expressed interest in viewing the property. At that point, the RED form should have been signed. 2. Providing implicit agency during the initial contract offer and the subsequent 7 weeks spent showing the buyer other properties. 3. Overlooking the dual agency situation when drafting the contract for the listed property within the same firm. Recognition of the dual agency status, particularly due to both you and the listing agent working for the same broker, should have occurred during the completion of Section 8s on the contract. Additionally, the limited dual consent form should have been signed by the buyer. 4. Never discussed how you would get paid and how all that works now with the new Seller Compensation Addendum and the BBEEA. Lastly, let's delve into the concept of acting as a facilitator without representing either party in a transaction. While this approach is commonly discussed in commercial transactions lacking a formal MLS or offer of compensation, it is deemed illegal in Arizona. Article 26 of the Arizona Constitution explicitly prohibits such facilitation, emphasizing the need for clear representation in real estate transactions. Section 1. Any person holding a valid license as a real estate broker or a real estate salesman regularly issued by the Arizona State Real Estate Department, when acting in such capacity as broker or salesman for the parties, or agent for one of the parties to a sale, exchange, or trade, or the renting and leasing of property, shall have the right to draft or fill out and complete, without charge, any and all instruments incident thereto, including, but not limited to, preliminary purchase agreements and earnest money receipts, deeds, mortgages, leases, assignments, releases, contracts for sale of realty, and bills of sale. It should also be added here that you as the buyer's agent must explain the new way of how agents receive commissions and that the buyer may be responsible to pay their buyer agent.